John Earle Sullivan, one of the Capitol Hill rioters, is now trying to get $90,000 back. If you recall, we were talking about this guy back on January 6th. He was running around the Capitol grounds and taking a lot of video footage of a lot of the mayhem that was going on that day. And he got some pretty good footage, actually. So good, in fact, that he sold it to a number of different media companies, including NBC and CNN. He made something like $75,000 to $90,000. Now the government is seizing that money. They're saying, you can't have that. That's ill-gotten gains. You got that from your criminal behavior, from your criminal conduct, and we're going to seize it. Well, he's trying to get that money back. He says, I need this for my life. I need this for my bills and my finances and my legal representation. And the government just issued a big memorandum saying, no, you don't. We're not going to give it back. We're going to tease out what's going on here. Let's take a quick look at Law and Crime. They say from their article written by Aaron Keller over the weekend, says that the government defends seizure of $90,000 from the defendant who sold his video to CNN and NBC. So while CNN and NBC and everybody was like, really, sort of hysterical over this, they had no problems handing one of these insurrectionists $90,000 for the footage. Oh, you almost just wrecked American democracy? How about we send you a check, though, for what you got on that cell phone? Okay. Federal authorities have seized more than 90 grand from a Utah bank account owned by the defendant charged with playing a role on the January 6th siege. The defendant, John Earle Sullivan, we just saw him. He licensed the video he recorded of the throngs of protesters outside the courthouse. Sullivan filed court papers describing himself as legitimately self-employed as a documentarian, asked that the government return the money. Okay, so sort of a this is a legitimate exercise of my power. I'm a journalist, and so journalists have certain protections under the First Amendment, and we give them access to certain things. Not the Capitol building during a riot, but I understand what this guy's attempting to do. According to documents on file in the U.S. District Court, Sullivan spoke with federal authorities several times after the deadly breach, beginning the very next day. He told investigators he was present when Ashley Babbitt was shot and killed and provided video of the incident. So that's why it was so valuable, because it was a very important video, right? There were a lot of people there, but not everybody caught and captured the shooting of Ashley Babbitt. Defendant's recording, which is still live on YouTube, we have a clip of it here in another slide, contains statements federal prosecutors have attributed to Sullivan, which suggests he was not merely just a passive observer. Quote, he said, apparently, there are so many people, let's go, this S is ours, F yeah, he said at one point, according to prosecutors. We accomplished this, he said. We did this together, F yeah, we are all in part of this history. Let's burn this down. We got to get this burned, he said. It's our house, MFers. We are getting this. There he is. Sullivan is being charged with all of these different violations. You can see here, they include civil disorder. They include entering, remaining on restricted grounds, disorderly and disruptive conduct. We've got possession of a dangerous weapon on Capitol grounds, false statements, a lot of other charges. See them all here, but you'll notice you have a different forfeiture section down here. So basically, as part of this document, the grand jury document, they're also saying we're gonna seize all that money. We're gonna take the proceeds that you got as a result of this unlawful activity. Here is a quick snippet of some of the footage. Now you'll see up here in the top right, courtesy John Sullivan. This is from WUSA 9, and so I clipped this from YouTube. So I think it's all YouTube friendly, but just bear in mind this, of course, is footage from the Capitol building. I just want to play this so you can understand what they're talking about. We're going to take a look at the memo from the government explaining why they should continue to seize this $90,000. This is some of the stuff that they reference in the memo. Here it is.
More water. I need more water. It's a revolution. Let's take this. This ours.
According to the Department of Justice, 26-year-old John Sullivan is charged with one count of knowingly entering or remaining in any restricted building or grounds without lawful authority.
Let's burn this down. I can't believe this is reality. We accomplished this. We did this together. Yeah. This is history.
One count of violent entry and disorderly conduct on Capitol grounds.
This is our house.
So you heard a couple of his quotes in there. We read the quotes. That's the video that they're talking about. Still have a lot of questions about what happened on that day, but we're going to see if we have a commission that forms in the Senate and if they do anything other than just try to politically steamroll their opponents, if they actually inquire about anything. I'll be curious as to what they find. We go back to the article before we take a quick look at what is in the memo. Government determined that the defendant received at least $90,875 in payments from at least 6 companies for the rights to the footage. We're talking $89,875 in payments went into his bank account, $1,000 went to Venmo, registered to his phone number and another personal bank account. Invoices say that he sold footage to CNN on January 6th for $35,000. So CNN is paying good money for this to an insurrectionist. And by the way, John Earle Sullivan, we talked about him. He's sort of a total outcast, it sounds like, from both sides of the political spectrum. So he sort of has some connections to BLM, but they sort of disavowed him. They threw him out of their organization. So it sounds like he was sort of trying to get into, maybe become a MAGA person, but they threw him out of the organization. And so he's kind of just this, nobody wants to be around this guy because he's so toxic. Now, you can be the judge of what that means, if anything, but CNN bought footage from him for $35,000. We have Australian Broadcasting for $2,500. NBC Universal paid another insurrectionist $35,000, and then Left Right LLC paid an insurrectionist $5,000. So we got big media here really kind of funding the insurrection to some degree. I mean, they're paying $90,000 for that. Sounds like they funded it. Interesting. The defendant's attorneys filed the invoices while describing Sullivan as legitimately self-employed as a documentarian, want pre-trial release, and the government is saying, no, this is all legal grounds. At the outset, defendant notes that he needs the funds in the seized bank account to pay his rent and household necessities. He says that the proceeds of the seized bank account are not the product of criminal activity alleged in the indictment. He's saying that the defendant is deprived of the needed assets in violation of due process. Prosecutors said, no, we don't agree with that. Let's take a look at what the memo has to say here. Government memorandum. This is filed out of the DC circuit, as almost all of these are. This was filed a couple days ago. I think this was on Friday, 28 pages. Again, we're not going to go through the whole thing, but I showed you previously that the grand jury, when they indicted him, they had a forfeiture allegation in there, finding probable cause to say that the funds at issue are forfeitable, so that they can actually take those. They don't have to wait until after a verdict. They're giving us a little bit of a background here on what happened, so I want to cover this briefly. At various times in his statements to law enforcement, defendant has claimed he was at the Capitol only to document and report. So what we're sort of talking about here is legitimate activity versus criminal activity. And what he's going to be saying is that, yes, I was technically in the building, so maybe that alone, maybe that trespass, that entry of the building by itself was a criminal act. But the thing that he was doing inside the building, which is documenting and recording what was happening there, is more in alignment with some of the journalistic protections that we have. We sort of allow, I'm not a free speech journalist attorney, but there are some additional protections to journalists for kind of doing their duty in the furtherance of free speech in this country. And so what they're trying to do is separate the two out. Yes, he was in the building. Yes, that was criminal activity, but the video recording itself was not criminal activity. If he were there, spray painting things or smashing computers or taking Nancy Pelosi's laptop or putting his feet on her desk or any one of those other things, walking out with the podium, right? All of that was criminal activity. That would have been theft. That would have been removal of property from within the facility. This wasn't. This is sort of just documenting things, more analogous to a journalist. So he's making that argument. And if you take that argument one step further, if you sort of extend that, extrapolate that out, well, if what he was doing inside was lawful, physically being inside was unlawful, but what he was doing in there was lawful, according to his argument, not something that I necessarily buy, but if you extrapolate that, then the proceeds that he got from that lawful activity of recording the footage would be outside the scope of the forfeiture indictment of that original document that gave them authority to go seize those funds. So this is where he's sort of trying to tease one out from the other. Not so sure that it's going to work. The defendant admitted to law enforcement, however, that he has no press credentials. Investigation has not revealed any connection between any journalistic organizations prior to the events of January 6th. So in other words, they don't buy it. He posted on January 6th a video from on or about January 5th, which he states to the camera. I mean, didn't I kind of make up a background, though, on the fly a little bit? I think I made up, what did I say I was? Oh, yeah, I was just a journalist, but I use that all the time. I'm just a journalist. I'm here recording. I got my camera on my shoulder. Literally, I have my big-ass camera on my shoulder right here, and I have my gimbal, so it kind of looks like it. Yeah, I'm just here recording the situation. Yeah, live streaming. Look, I have people on my live stream. That's why I pulled it back out. Defendant also said on his live stream video that he posted on 11th through 13th of December, says, I don't make money off of it, so I don't consider myself a journalist. Uh-oh. But as far as like reporting stuff like I am now, I'm an activist too. So like it kind of plays hand in hand. But as far as like being a journalist, it would be cool to be one. I don't have anything against it. So in fact, he's not a journalist. Not a journalist. Not a journalist. On January 6th, however, he was captured in recordings by other individuals shortly after exiting the Capitol, expressing excitement that he captured the shooting of the woman on the film. The defendant stated, everybody's going to want this. Nobody has it. I'm selling it. I could make millions of dollars. The defendant also spoke like someone on speakerphone, stating, I brought my megaphone to instigate S. I was like, guys, we're going inside. We're effing S up. I'm going to make these Trump supporters F all this S up. Oh, see that? I'm going to make these Trump supporters F all this S up. I mean, you'll see. I have it all. I have everything. Everything on camera. Everything I just told you. I mean, everything. Trust me when I say my footage is worth like $1 million, millions of dollars. I'm holding on to that S. So pretty impactful statement right here, right? You know, a lot of people were trying to say that this guy was a MAGA maniac, somebody who was out there part of the Trump crowd, allegedly trying to steal the country on that day. I guess we've talked about this. In America now, if you take the podium from the Congress building, you control the country. So we learned that from the media and a lot of our elected officials this past January 6th. I didn't know that, didn't learn that in law school, but apparently that's a thing now. So this guy, many people were saying he was one of those people. He wanted the podium. He wanted that special ring and all the power associated with it. But sounds like maybe he wasn't. He says, I'm going to make these Trump supporters F all this S up. But I mean, you'll see. I have it all. I have everything on camera. So it kind of sounds like to me he was sort of instigating the Trump supporters. Sort of he was like excited to hurry them along. Or maybe those other people were not Trump supporters like this guy was. Maybe they were also instigating stuff like he was. I don't know. I mean, this is in the prosecution's document. They filed this. The government that is prosecuting this guy, prosecuting a lot of the other Capitol Hill rioters from their document. So they know this, that's what he said. Okay, we can continue on. Open source news reporting has also detailed how in the days after January 6th, the defendant repeatedly changed the self-description of the homepage on his website. So he got a lot of activity, so he had to go update his social media pages, of course. On January 10th, he changed the description from activist to athlete to motivational speaker to activist to video journalist to athlete. Over a photo. Oh, so that was all one thing. Activist, athlete, motivational speaker to activist, video journalist, athlete. Okay. He's using threes, which is good. The rule of threes is pretty good about that. You always sort of, keep things in groups of three. On January 11th, that's for marketing, that's for law, that's for sort of establishing themes and telling stories. Rule of three is a good one. On January 11th, 2021, he again updated that text to video journalist, activist, and athlete. Changed the image to a loop from his video at the Capitol, and then he just called himself a video journalist. So he's going through a little bit of an identity crisis, which is very common in 2021. So on February 15, 2021, prior to a hearing on pretrial release conditions, his attorney filed a pleading with the court attaching receipts for services documenting the defendant's employment. I would like to see what those receipts look like. Based on the pleadings, the government determined he received just under $91,000. We went through that. Procedural history. It's working its way up the courts. They're defining what proceeds mean. Warrants were served. The government seized a total balance of $62,800 from the bank account. So he made about 90. Looks like he spent around 28 grand. I wonder where all that went. On May 19th, grand jury returned a superseding indictment that added weapons charges, false statement charges, and forfeiture allegations. Oh, so that's brand new. So he's got new charges coming. It says that he obstructed, influenced, impeded official proceedings. So he got some weapons charges now. They're saying here, the argument, it's well established that the government has an interest in obtaining full recovery of all forfeitable assets. The defendant's request for a hearing to challenge the seizure of the funds should not stand. They're saying it's based on probable cause. Here are a couple quick details. They're saying that his bare bones assertion that the funds are needed for household expenses does not merit a pre-trial hearing. So it sounds like what he wants to do is just basically schedule this for a hearing. Say, courts, I need this money. Let's have a hearing about this. The prosecution is coming back and saying, well, just the fact that you need it, that's not enough. In fact, the threshold has to be considerably higher. So a couple other standards here, laying down some rules for us. We have Cayley versus the United States. Supreme Court is telling us that pretrial seizures require probable cause for 2 elements. Number 1, that the defendant has committed an offense permitting forfeiture, and that the property at issue has the requisite connection to the crime. So I think this is really where they're going to be hanging their hat on. The idea being that the recording of the video itself is not closely connected to the crime. The crime really being the breaching of the Capitol building. It's the trespass. It's going inside. But the recording of the video, once inside, is not a close nexus to the criminality. But I don't think it's going to hold up. In effect, the defendant asks to extend the qualified right to pretrial hearings from the right to counsel context to household expenses. Sixth Amendment concerns do not necessarily translate. So this is right to counsel arguments we see here. We've got Chief Judge. So in a prior segment, we talked about a lawsuit that was filed by the Chinese Civil Rights Coalition. And you'll notice that in that document, we didn't see much of this. We didn't see any citations. Here we actually have some citations. So this is what you'd be looking for in a legitimate document. Another reason the government says that he should not get the money back in any event the defendant's threshold showing of necessity for the seized funds is undoubtedly inadequate. So they're saying he hasn't shown that he actually needs this. Courts say that in the Sixth Amendment context, every court has addressed the issue that found the defendant's merely conclusory allegation that he lacks funds to get an attorney is insufficient to trigger the Monsanto hearing. Instead, what does a defendant have to do? They must present some evidence that he will be deprived of counsel of choice if he cannot access the seized assets. So it's a little bit of a different standard, right? Think about these from 2 different perspectives. One, if you're a defendant and the government comes and they seize your entire bank account, one way that you can approach that is you can just say, hey, government, I need that money so that I can go hire an attorney. Well, if that's all the evidence you've got, just a claim, I need it. You need the money back for what? For an attorney. Okay, well, we need more than that is what this court is saying. We need something very specific. We need you to show us what the attorney is, how much they cost, what your financial records look like, what would make it impossible for you to retain the attorney of your choice. And if that impossibility is directly related to the seizure of your funds, then maybe the court will consider opening up those funds only for the limited purpose of giving you the exact funding necessary to provide for your legal defense. So it's sort of like asking mom for money for school or for a dance or whatever you're doing. Mom, I need $20. What does she always say to you? What does mom say to you? For what? What do you need that for? $20 for what? Pizza? No, you get $5 for pizza. Okay, that's it. Get out of here. $20 is too much. So here they're saying, well, you come back and show us what you need. Now, when you go to your mom and you say, Mom, look, Mom, the Ferris wheel's $1. I got to buy some popcorn. That's $1. I got to do this. And okay, well, you get $8.50 then, right? And then when you get home, you got to do the dishes and do the chores. Love you, Mom. But the point is, it's very, very specific. This complaint continues on. They're saying that the defendant assertion falls short of even the undoubtedly inadequate standard, where the defendant said in a sworn declaration, he said specifically, beyond the money seized, I do not have any funds to pay Attorney Belezo's retainer. We said, okay, well, that's not enough. We need a lot more information. We need to know about your dependents and about all of your revenue and about money and cash on hand and money in savings and money in checking accounts. Not just a bare suggestion that you can't afford it. That's not good enough. Here, the defendant in this case, Sullivan, submitted no declaration, no financial affidavit, no banking statements. He has not provided any information about his assets outside his bank, his account ending in 7715, or anything else. No detailed sources of income, no government understanding about his employment. No, he's currently employed by his father. No other assets, descriptions, nothing. So the government is aware of at least one other bank account. He has a positive balance in there. So the government knows where your money is, folks. He says the defendant bears the burden of persuasion to establish the bona fide financial need to use the seized funds to maintain basic necessities. The motion's conclusory statements fall well short. Couple more here. The seized funds are traceable to and they're sufficiently connected to the defendant's obstruction of a proceeding. So this goes to that second prong. He's saying that when he went in the building and was just recording the footage, that was not close enough. That was not close enough as a nexus to the criminality. Video is not a crime, is his argument. Prosecutor here is saying, yeah, it is. The defendant's motion asserts that the proceeds of the seized bank account are not the product of the criminal activity alleged in the indictment. That criminal activity was entering the building, not recording. He's not charged with recording a video. He's charged with recording and breaking into the building. The 19-page affidavit on which he relied contains no disclaimers of traceability. Should this court reach this issue, they're saying that based on the totality of the facts and evidence specific to this case, a strong nexus between these proceeds and the crime exists. Basically talking about this concept of a gateway function. The governing standard for the causal connection between the proceeds and the crime is a but-for test. Under the but-for test, which has been adopted by DC, proceeds mean that the property that a person would not have obtained or retained but for the commission of the offense. So a very important concept in the law. What they're saying here is that if he would not have committed the crime of breaking into the congressional building, he would not have captured the video footage, right? He would have been outside the building. So he wouldn't have been able to see anything from the inside of the building. In particular, we're talking about the Ashley Babbitt footage that CNN and NBC paid almost $70,000. They paid $70,000 for. So if he would not have been in the building, he would have never captured that footage. So the 70,000 plus the other 1,000, total $90,875 would have never gotten that if he had not committed the original crime of breaking into the building. So I think that makes sense logically. They say the defendant would not have obtained the footage inside the Capitol at all had he not unlawfully breached and remained in the building. He was there with close proximity, frontline vantage points. So they just go through everything. He even tells officers trying to usher him in, he says, we're just recording. There's too many people to be acting like this. Like you're not solving anything. He says, I'm just recording events. It's not worth it. I'm just trying to record. I'm just filming. No freedom of the press. See what he's doing. At another point, he tells someone, that's why I'm a photographer. That's why you got to have ID. But in the speaker lobby doors, he tells one of the law enforcement officials going in the doorway, we want you to go home. I'm recording, and there's so many people, they're going to push their way up here. Right. Meanwhile, the commercial value of the footage was substantially the result of his proximity as a front-line participant. He was the eyewitness of the video shooting. That's why they paid $70,000 for it. If he was outside the building, well, they had a lot of people recording that stuff. That's not worth anything. This is worth a lot because it's the shooting of Ashley Babbitt. Defendant boasted at least twice upon leaving the Capitol that he would make millions of dollars from his footage. It bears to mention that although the defendant's proceeds happen to pertain to video footage and to entail transaction with the media, the government's theory of forfeiture is content neutral and serves content neutral purposes. So has nothing to do with any political ideology or anything like that. They're saying it's just a matter of fact. He got money in the commission of a crime and they want to seize that. So they say, should the court reach this issue, there's probable cause supporting the proceeds of the crime to be seized. They request that the government deny or that the court deny the defendant's motion to release the seizure order and forbid seizure of other counts. They want the trial to continue. They want the court to deny a pre-trial evidentiary hearing at this time, signed off by Channing D. Phillips, acting U.S. attorney. It's signed off by Candace Wong here. So I think the government's probably going to hold on to that money. Probably. Now, we do know that he may have some other sources of funds. So he is actually writing a book. Here's Earle Sullivan here on Channel 13 Fox News.
Sullivan reads words from the first chapter of his unfinished book, the one he's been writing while waiting for his trial.
When I was on house arrest, I just sat there and just wrote it all out.
Sullivan is writing about what happened at the U.S. Capitol on January 6th and the groups he says were involved.
Show how these two groups kind of, came together in forming that narrative that built up to the Capitol.
Sullivan was arrested in the summer of 2020 for organizing a protest in Provo where shots.
Yeah, so that's some of his other protests. I think he was with the BLM organization or an Antifa organization, one of those two organizations, and they threw him out. Like, we don't like you. So that's John Earle Sullivan. Let's take some questions over from watchingthewatchers.locals.com. We have Sharon Quidney says, here's yet another example of government overreach and total annihilation of our civil liberties. They probably seized his money to help pay off some of the debt from the insane spending spree they've been on lately. Wonder how many other folks they're going to come after. We got Bessa. Thank you, Sharon. We got Bessa Miento says, Sullivan is an Antifa BLM activist who bragged about infiltrating MAGA by wearing a MAGA hat. Yeah, I that's what I thought I had heard that. And Sharon says, I wanted to, insane spending spree they've been on lately. Yeah, there was another story, I think, that there was, 300, 400 cases now total that they're prosecuting now. So his is being added to that list. And Sharon, you made me think about this. I wonder how many other people are having their assets seized in general, right? We know this one is a big number. This is $70,000, 90 in total, because it came from very viral footage. We all saw the footage. Everybody knew about this. But what about other defendants? I wonder if they're seizing anything from them. Besamiento says, yeah, he's a BLM supporter. Definitely heard that. We got Sharon Quidney says, yes, it's a raindrop in the ocean, but if the government gets away with stomping on this citizen, they'll feel empowered to come after anybody who said or did anything pro-Trump, including voting. Yeah, forfeiture is actually a big issue. I didn't really talk about this story to dive into the forfeiture issue, but the government does seize stuff all the time, and big chunks of money. I mean, they'll charge you with a drug crime and then hold on to your car, forever. Why? I don't know. It was used in the commission of a crime, along with a laptop that was in there, a lot of cash, stuff that may or may not be connected to the crime. In my opinion, it's not even close, but they can connect it just based on the fact that it's in close proximity, and they take a lot of money. You're seeing a lot of forfeiture reform and civil asset forfeiture reform being discussed in this country in close proximity to criminal law, as it should be. It's actually a very big issue. Leafy Bug is in the house, says BLM and Antifa have only distanced themselves from this guy because they don't want to be tied to the January 6th riot. It's really strange how he isn't in jail awaiting trial like the other trespassers. Just happened to be in the right place to video Babbitt shooting. I wonder what else he knows. He seems to be getting special treatment. Yeah, I'd be curious. We have Liberty or Death says, wow, look at all those law and case citations in this complaint. Interesting. I know. It's, oh yeah, they are supposed to be there. Oh yeah, she just forgot. And the other one, silly. We have NY Renal MD says, I stipulate for the court, my client is an idiot, not an activist or an athlete. I see what you're doing. Idiots are also protected by the First Amendment. Shame on the prosecution. So yeah, he's basically just agreeing. Stipulation means you're just agreeing to some fact. So rather than us trying to duke this out, activist, athlete, journalist, we just say, okay, we all agree, moron, not too bright. Right. I'm not calling him a moron, but I get the joke. We have NY says, sorry, Judge, I need a lawyer to prove I need a lawyer. Yeah. We have good to see you. We have Chaskow says forfeiture before being convicted of anything smacks of no due process. Civil forfeiture is abused by the government all the time, needs to be reformed and or eliminated in most cases. Yeah, it's actually a big issue, right? And I of course, this audience is highly informed on these issues. But it is a big issue. I wasn't sort of talking about the story for that, but it is, right? You sort of see what happens. The government just says, well, we think that that's our money now. And you say, well, I haven't been convicted of anything. What happened to my presumption of innocence? He hasn't pled guilty. His trial hasn't happened yet. He hasn't been convicted. The government just gets a warrant and just goes into your bank account and just takes money out of it. And you got to go fight to get it back. And you got to prove sort of that you're not guilty of that. Is that a fair thing? Not really. We have Jack Elia says, is the purpose of demanding complete listings of the intended use of the money so that the court's officers can potentially initiate tracking and surveillance on the activities of those to whom it goes? It's a good question. And the answer, I think, would be yes, right? You're still under investigation. So you're opening that up. And they probably already have access to most of that. I mean, they knew about all of his other bank accounts. So in their initial warrants, presumably the judge said, yeah, you can monitor all of those things. Go take a look at whatever you want. And the basis of that authority, of course, was the Capitol Hill riots. This guy's a dangerous insurrectionist. So the judge, whatever you need, whatever you want, 90 grand, it's yours. Enjoy it. All right. Great questions. All of those came over from watchingthewatchers.locals.com. Thank you so much for your support over there. And be sure to check out our upcoming events because they are a lot of fun. We just had our monthly meetup. Really enjoyable. We've got another one coming up next month. And then guess what? The month after that. And we hope you can join us for all of them at watchingthewatchers.locals.com.